So, welcome to Professional Ethics, November 2021, past paper. My name is James Githaka Nginya. I'm an advocate of High Court of Kenya, founder of Bar Exam Preparation website, which also have a YouTube channel. I've been doing online classes since 2023, so this is the third year. Professional ethics is one of the most failed subjects, especially from the results that were released in November 2024, and also the second most failed subject from the results of November 2023. So I believe I need to create content. The papers that I've researched on the website are year 2009 to 2019 profession Q&A, which are the past papers from 2008 to 2019 combined 500, June 2021 100. So we are in November 2021. Father, I come before you, Lord. I adore you. I respect you, King of Kings, Lord of Lords. Let me deliver this class, this recording. Well, I pray God, as I upload it on my YouTube channel, let there be a lot of views, subscription, so that I can be able, God, to be monetized. Let the participants who are going to, the people who are going to view the content on the YouTube channel, to help them to pass their exams in April 2025. I pray all this believing in Jesus Christ, my Lord and Savior. Amen. So, yeah, I'll share the paper now. So for this class, we are going to deal with question 1, 2, and 3. And then the next class, we are going to do question 4, 5, and 6. Yeah, so I'm going to read the question, which is projecting on the screen. Dr. Fisi is a renowned and highly connected business mogul dealing solely in high-value pharmaceutical products. He calls himself a doctor because he has been trading in pharmaceutical products for over 4 decades and has accumulated a considerable knowledge and experience despite his modest formal education, which had terminated at high school level. He says he's a pharmaceutical drugs trading professional, PDTP. He has made a considerable fortune from trading and being a very generous man. He is highly respected in the pharmaceutical industry in Kenya and abroad. He always sees it as a profession like any other formally trained doctor, engineer, lawyer, teacher, etc. Etc. He handled a multi-billion contract as a sole importer, supplier, distributor of the COVID-19 vaccine in Kenya. However, due to the reasons He has declined to disclose the tender was cancelled and awarded to a company called Quickfish Limited. He's infuriated. You want to work at Dr. Fish has voted your name to him. Dr. Fish has approached you to represent him. It is barely a month since your admission as an advocate of High Court of Kenya. This presents a great opportunity for you to accumulate fast capital to set up your own law firm. Having looked at the relevant document, you are convinced it can do either way, but you diligent research and diligently you can win. Dr. Fish insists that they must win case or do or die. He's preparing to pay you any amount as the fees as long as you win. He wants you to do everything possible to win the case. He insists you must have the case fixed before a specific judge. He has named which is not difficult task for you. He wants you to get the money first and talk about ethics later. You need the money anyway. He also wants you to rope any advocate that may come on record and for the opposing party. He's ready to talk to him or her. He's eager, ready, willing, and able. You're anxious about, but you feel excited. You are ravaging to undertake the task, but some fears and questions keep coming in your mind, and you want answers. Discuss the following. Is the observance of professional ethics a priority in face of once in a lifetime opportunity and the harsh economic times occasioned by COVID-19 pandemic? Yeah. So if you want to pass professional ethics, you must have this in mind. Uh, I divide professional ethics into three areas. First of all, the journey of a person to become an advocate. Yes, this is pre becoming pre advocate. Yeah, before you becoming an advocate. So where this is where you must understand the Legal Education Act and the Kenya School of Law Act and the admission criteria, all those things. Then when you become an advocate, now this is where most of the question comes from. Testing your ethical behaviors and practice. So you must know mainly the Advocates Act and its regulations, and there are very many. Then the LSK Act and its regulations. Then the LSK Code of Standard and Professional Practice and Ethical Conduct, 2017. Yeah. Then an advocate can become, those are advocates in private practice. An advocate then can become a judicial officer. So you need to know that is now part three of professional ethics. I divide it. An advocate can work in DPP office, so you need to know the conduct of prosecutors. Advocates in the public sector, so you need also to know like Public Officers Ethics Act, etc. County attorneys, you need to know the Office of County Attorney Act. So professional ethics as those three areas. So before someone become an advocate, when someone is an advocate, and when someone is employed in other areas or takes employment when it's not in private practice, that is. So, but the main area is an advocate in private practice. Yeah. So we go back to the question. Is observance of professional ethics a priority in face of once and after opportunity and harsh economic times occasioned by COVID-19 pandemic? Of course, yes. That is the answer. The question is 4 marks. So you must give 4 points at least. Uh-huh. So the answer in this is yes. So yeah, and you answer. You will get it from the Code of Standard of Professional Practice, Ethical Conduct, Code of Conduct, 2017. Uh-huh. And it is under the variety principles. So, point number one, the advocates need to have professional independence. Is key ingredients on an advocate to provide professional service to the client objectively. So this client need to not to be influenced by the client. Yeah, Dr. Fish. You don't need to be influenced by Dr. Fish. Number two, honesty and integrity is another variety objective of an advocate. Point number two. So honesty and integrity are the hallmark of a legal profession, but exhibited in every legal profession in her dealings with the client. So when he's saying that he wants to influence the judge in an appropriate way, you not be having honesty and integrity. Number three, point number three, fidelity to the rule of law. Uh-huh. So when you are being told that you are going to win case at any cost, that means you may even bribe and case fixed before a judge. So they are not adhering to the verity of the law. So the legal profession is the rule of law and due process. Yeah. Uh-huh. So that is point number three. Yeah. Point number four, professionalism. So lawyer must demonstrate professionalism in his dealing with client, fellow professional, and third parties. So when it is doing all these things, you are not showing professionalism. Yeah, and that is your answer for question 1A, November 2021. Yeah. So question B, 1B, is pharmaceutical products a trading profession like in any other as Dr. Physics claims? 6 marks. So you give 6 points. So you are being told from the question that Dr. Fisi, for decades and has accumulated considerable knowledge and experience. He has formal modest education he terminated at high school. So he called himself Dr. Fisi, and his education, he has a good education. Then he says he has a pharmaceutical drugs trading professional. So remember, so for a professional, is a business. I'm projecting the answers of best and worst candidate. So he's not a doctor. So pharmaceutical is not a professional, but rather a business. A business defined a carry for purpose of making profit. Mhm. Yeah. So point number one, possession of special knowledge. Dr. Fitz does not possess special skills or knowledge. He has not undergone training. Mhm. That means for you to be for you to register to have a pharmaceutical company, you must be a pharmacist, and a pharmacist must be registered by Pharmacists and Poison Board. So you need to have gone to class. Mhm. That is point number one. Oh, then, yeah, those are like 2 points. Uh-huh. So he needs also to have registered his company. So that means he needs to have a business name. Uh-huh. That is point number two. You can operate as you need to have registered a company through business registration service. His business also need to have been inspected by Persons and Poisons Board, which has not been done. You also need to have a premises registered at the pharmaceutical operation is Kenya. Uh-huh. You need to have a practicing license for the year. Yeah. So that is that some of the answers. Combining with the answers given by the best and worst performing student, you get your 6 marks. So next question. The advocate shall are the parameters that inhibit you to from asking of any amount of money as legal fees since the client is ready to pay any amount. Yeah. So this other question, 6 marks, gives is asking you what guides for you as an advocate when you are charging a client. So first, point number one, you say that question B not let's go back to question B. Question B was not necessarily a professional ethics question, so its chances of coming again is very low because it's asking you about yeah. So see, in terms of legal fees, you talk about the advocate is bound by advocate remuneration order, which sets the scale. Point number one, you can give a case law of Ahmed Nasir, National Bank. So Section 236 prohibits undercutting. You give the case of Abdikariva National Bank. That is point two. Point number three, it's not ethical to charge exorbitant fees as hinders access to justice and may lead to commercialization of the profession. Point number three. Remember, I advocate you write in point form, not paragraph, for your points to be, for the marker to easily see your points. Point number four, other consideration an advocate takes into account when charging a client, you give the factors, the reputation and experience of the lawyer, the value of the subject matter, the workload involved, the relationship an advocate has with the client. That is point number four. Uh-huh. Yeah, so that those are 4 points. So you can also add another point which was not given by best and worst performing student. That is section 45, one of the Advocate Act. Which talks about agreements with respect to remuneration. So before or in course of contentious business, there made an agreement. You can fix an agreement between you and your client in respect of the matters. So that was another answer. And you're going to get your 6 points. D. Question 1, D. November 2021. An officer of the court illustrates at least two compelling duties you owe to court that prevent you from proceeding to the Fishes request to have the case fixed before a specific judge. So, what are the professional ethical practices that makes you not, as an advocate, not agree to cede your request for the matter to be fixed before a specific judge? In another case, the question is asking you for your duties as an advocate to the court. 4 points. So point number one, first of all, an advocate is an officer of court under section 55 of the Advocates Act. Uh-huh. So he has a higher duty to uphold the interest of justice than the interest of client. You discuss Roder versus Wassily case. Point number 3, you have a duty not to mislead the court. And you explain. Then you have a duty not to to inappropriately influence the court, because corruption must be involved when you are fixing a matter before a specific judge, and it's against the overriding objective, the one we did in and at question 1A. When you explain, you get your 4 points. We go to question 2. Justice Crassus Thomas, the longest serving associate justice of United States Supreme Court, stated, "Good manners will open doors that best education cannot." So what do you understand by the term courtroom etiquette? 2 marks. This is a common sense question, and it's going to give you 2 marks. So courtroom etiquette refers, I'm projecting the answer given by the best performing student. Courtroom etiquette refers to the conduct that is courteous and generally regarded as good manners by virtue of common sense. One should carry in themselves with general decency in a courtroom. Yeah, you can also, it means being respectful, address the judge well, your honor, your lady, be courteous to the judge, staff, and other parties. Don't use offensive language. Be kind. Yeah. So that is court etiquette. A simple question. Give you 2 marks. So your friend is making a Mayday speech as a lawyer in an open court. He said 4 rules of court etiquette should observe. So this friend of yours is appearing as a lawyer in an open court. So what are the rules of etiquette? Another simple question. So if I was doing this paper, of course, question 1 was compulsory. I will do also question 2. So number 1, refer the judge to the proper name. Example, your honor, your lordship. Bow when the judge enters the courtroom. Keep time. Don't leave the courtroom before the judge of the magistrate. Sit quietly unless the judge or magistrate asks you to speak. Give the judge and magistrate full attention. Turn off your cell phones. Do not film, record, or broadcast proceedings. So that's some of them I've added on top of the answers given by best and worst performing student. Question 2C, November 2021. The advocate shall also be making a maiden appearance in a virtual court via Zoom platform. Discuss whether rules of etiquette apply in virtual platforms and how. So question B was on physical appearance. Question C was on virtual appearance. So they apply. On top of that, I'm projecting the Supreme Court of Kenya Virtue Session Practice Direction 2023, gazetted by the Chief Justice Martha Koome. So we can get some of the points there. So, Practice Direction 14, during virtual proceeding, inappropriate profiles or background photos shall not be used. Failures which may lead to denial. So you must put appropriate profile in your camera. So you must be properly robed. So advocates and parties where they appear must be visible and audible during virtual session. So you must also log in a video and audio conference using your visual name. All microphones should be muted until the advocate or party is given audience to speak. So that is some of the things that apply in virtual courts. So you can study the Supreme Court Virtual Session Practice Direction 2023 and you earn your 4 marks. This was a simple question 2. And this is a question someone could have gotten all the 10 marks. We got to question the last question of the day. Question 3, November 2021. On that March 2021, 2 weeks after completing the advocacy training program, Jerry attended a session of the Advocate Disciplinary Committee hearing as Professional Center in Nairobi. She was taken aback by the sheer number of advocates being prosecuted. She thought the numbers were too high and compared to the total number of advocates in Kenya. Of particular interest were 3 advocates, one being her relative, while the other 2 are her mentors. The 3 cases baffled her. Advocate Kurayote, who is her relative, is alleged to have represented the vendor and purchaser in a transaction involving a sale of prime property in Karen, Nairobi. He persuaded the 2 parties to retain him to reduce the cost of legal fees as well as maintaining the transaction. The purchase price was shilling 40 million, which the purchaser deposited with him in full, but 1 year later, the vendor had not received any payment. The transfers is yet to be registered. Renowned advocate Kunywa Mingi is alleged to have been absent from court in a matter and on dates fixed in court, his presence and by consent. That although the case was coming up for full hearing, his client came to learn about it from the court clerk when we went to complain that the court is delaying the case. He did not prepare for the case, and is apparently he had never diarized the date since the members of his staff at the office were not even aware that the case was coming up. Advocate Sungura is alleged to have received 2 million and disappeared. He not informed his client he received the money after sending a demand letter. He cannot be reached on phone as his last known address is no longer in use. For your knowledge in professional ethics and practice, explain to Jerry the following. So, question A. At least 2 instances of professional misconduct committed by each of the 3 advocates if the facts are held to be true and accurate. So you must give 2 professional misconduct by the 3 advocates. So Advocate Kulayote, we are being told that he persuaded the 2 clients to retain him and reduce the costs. So welcome Wakiaga, how are you?
I'm all right, Mwalimu.
So I've gone. In fact, I'm finishing.
Okay. It's unfortunate. At my place of pupillage, we've left very late.
Okay.
Yes.
So don't worry. So you can see the question.
No, I cannot see anything.
Okay, let me share. Now?
Yes, now I can see it.
So, yeah, I can repeat the question again. I'm now at, when someone does not attend, I usually do the recording, So I'm going to repeat question 3 again so that we finish together.
Okay, I think that is all right.
So on September 3 March 2021, 2 weeks after completing the advocates training program, Jerry attended a session of advocates committee hearings at Professional Center in Nairobi. She was taken aback by sheer number of advocates being prosecuted. She thought the number was too high compared to the number of advocates in Kenya. Of particular interest were 3 advocates, one being her relative while the other 2 were her mentors. These 3 cases baffled her. Advocate Kulayote, who is her relative, is alleged to have represented the vendor and the purchaser in a transaction involving a sale of prime plot in Karen, Nairobi. He persuaded the 2 parties to retain him to reduce the cost of legal fees as well as expediting the transaction. The purchase price was 40 million, which the purchaser deposited to him in full, but 1 year later, the vendor has not received any payment. The transfer is yet to be registered. So, 2, renowned advocate Kunywa Mingi is alleged to have absent from court in a matter on the date fixed in court in presence by consent. That although the case was coming up for hearing, his client came to learn about it from the court clerk when they went to complain that the court is delaying his case. He did not prepare for the case and apparently he never diarized the dates, hence members of his staff, one of his staff and the office were not even aware of the case was coming. Advocate Sungura is alleged to have received 2 million and disappeared. Did not inform his clan that he has received the money, and after sending a demand letter, he cannot be reached on phone, and the last known address is no longer in use. Yeah, so question number 1, 5 marks. From your knowledge in professional ethics and practice, explaining to Jerry the following: at least 2 instances of professional misconduct committed by each of the 3 advocates if the facts are held to be true and accurate. You can answer?
Yeah, the first one, I can actually see conflict of interest here.
Yes.
Where is it? And the second one, I'm seeing is it also there's the problem of honesty and integrity. And the third one, which I can actually see, there's also the question of competence and diligence.
Yes.
Yes, those are the ones I can actually identify from what is going on in this question.
Okay. Yeah, so the question is asking you to at least 2 instances for professional misconduct committed by each of the 3 advocates. So you must give 2 for each and every advocate. So for advocate Kulayote, there's conflict of interest. So you explained conflict. What is conflict of interest? It's acting for 2 clients, and they have not consented. Yani you conflict. You can act for 2 clients, but there must be full disclosure of the consequences of acting for both of them. But here you see that he has persuaded them to retain him because they reduced costs of legal fees and expediting the transaction. So that is number 1. Number 2 is it is called failure to render professional services on time. So he has delayed this transaction. So point number 2, Advocate Kulayote will be charged for failure to render professional services on time. So that is another charge usually because the transfer had been delayed. So when we come to Advocate Kunywa Mingi, so failure to render professional services, that is being absent from court, and failure to
is it
dialyze
and diligence?
Yes, and diligence, yeah. And diligence, failure to dialyze the matter. Unaona? Then when you come to Advocate Sungura,
Yes,
is dishonesty. And failure to inform and crossing his business premises. Remember, under the advocate's regulation, you must maintain a physical presence. You must have a physical address. Is it under practice rules?
yes, it's actually under advocates practice rules. I think so.
Yes. So that is for question number A. So the disciplinary procedure that was followed so you explain now to Jerry next question, the disciplinary procedure that was followed to the point when Jerry attended session on 3rd March 2021. 3 marks. So those are 3 points.
I think the first one is to report to the disciplinary committee, is it?
Uh-huh.
Yes,
Uh-huh.
then the disciplinary committee will then hear both parties. So after hearing both parties, the disciplinary committee will make a decision whether there is professional misconduct or not. If there's professional misconduct, then they will impose sanctions on the advocate. If there is not, then they will discharge the advocate.
So that is a very good trial. So this question is talking about. Remember, Jerry has gone to the advocate disciplinary committee hearings. So the question is asking you the procedure that was followed to the point where Jerry attended the session on 3rd March 2021. So what was the what happened before that? This is what the question is asking you. So as I did my introduction, I said you must understand your Advocates Act very well. So the first point is point number 1. Your answer is found in section 61 to 3 and Advocates Disciplinary Committee rules. So point number 1 is the person made people who are the client made complaint through an affidavit. So that is point number 1. Where they set the allegation of professional misconduct. So that is section 82. You can also look at rule 8 of the rule 8, 13, and 14 of the Advocates Disciplinary Committee rules. So after the affidavit allegation, what's happened next? If you have done your civil litigation or criminal, the advocates must reply. Yeah. So the section 3, section 63, where a complaint, section 63 of the Advocate Act. When a complaint is referred to the tribunal under part C, the tribunal shall give the advocate agrees with the complainant is made an opportunity to appear before it and furnish him with a copy of the complaint and any evidence in support, and shall give an opportunity inspecting any relevant document not less than 7 days before date of hearing. So those are the preliminaries that happened before the hearing. And you earn your 3 marks. This question was not done by the best and worst performing student. So the question 3 was not done. It's a question that is omitted. Question 3C, the last question of the day. What possible sanction could be meted against any of all the advocates is found guilty of the alleged breach of professional conduct? Explain at least 2. Wakiaga?
Yeah, the first one is that their practice certificates may be withdrawn. Yes, that is one. There's also a possibility of being struck off the role of advocates for some time, for a period of time. Yes, I'm not very sure whether the element of fine can come in.
Yes. So explain at least 2. Which instances that those 2 happen?
when when the certificate of practice is withdrawn, the advocate will not be able to practice for a period of time, for the time that, no, I think there's somewhere I read that when a certificate of practice is withdrawn, you will stay without that certificate until the end of the practice period. That is for that particular year.
Yes.
Yes.
So yeah.
And yes. And when struck off the role of advocates, it can also be for a particular period. You can be struck off the role of advocates for a particular period, and if the advocate is not satisfied with the decision of the disciplinary committee, the advocate may appeal to the Chief Justice. Yes, and the Chief Justice may give his or her verdict as she or he wishes, may uphold the verdict of the disciplinary committee, may also overturn it, but with conditions or without conditions.
Yeah. So your answer is correct. To the only part you did not get correct is the all decision of advocate disciplinary tribunal. You appeal to the High Court.
Oh, okay, to the High Court. Okay.
Yeah. You appeal to the High Court through a judicial review.
Oh, okay.
So it's not the Chief Justice. So the penalties are found in Section 64 of the Advocates Act. So number one is the advocate may be admonished. So for very not very serious allegations, you can be admonished or reprimanded, or you admonished mean that you can be kuteteshwa yani, yeah? You know what admonish mean?
They might impose some sanctions on you.
One or reprimand, one.
Or reprimand, yes.
One. So, like for example, where the question they are saying that for like advocate Kunywa, this is not very serious, being absent in court because the hearing did not proceed.
Yes.
And they are not diarized. That is not very serious. There was no advance orders that were given against the client. So in that instance, it can be admonished. That is number one. For non-serious things or failure to communicate. So another thing is advocate can be suspended from practice for a specified period, not exceeding 5 years. So yeah, these are not for also serious, but not very serious, which also include that the advocate can be fined a fine not exceeding 1 million. So like for example, in our question, if they cannot withdraw a practice certificate for Kurayota because they want him to finish the transfer. So here they can fine him for delaying the transaction and for conflict of interest. But now, where someone have disappeared with money kabisa and it cannot be traced, you are usually given time to repay the client. And if you cannot be repay the client, you are struck off. Yeah, struck off. Then another penalty, you can be told to reimburse. compensation of an embarrassment not exceeding 5 million. So this usually applies where so in our instances here, Advocate Sugura can be struck off because he had disappeared with the money and he cannot be reached on phone. And his address become he has closed the law firm. Then where you have charged exorbitant fees, yeah, you can be told to do what? Section 64E, you can be told to pay compensation, or where the client has gone lost or reimbursed the money. Yeah. So that was it.
Thank you so much, Wakili.
Yes. So